Advanced directives. Something's changing and you know you're going to want to know what to do in the future. Well, don't try to do this alone. You're going to want someone involved who knows what they're doing, an expert. And so we brought Robert into the picture. So Robert?
Good morning. Thank you for having me. My name is Robert Brooks. I'm with the Heritage Law Group in Yorktown, Virginia. We specialize in elder planning, elder law care, advanced medical directives, power of attorneys, wills, trust, obviously Medicaid, and all the sorts of stuff that falls into place.
All right, Robert. Now I'm going to pause this a second here because, wow, that's a lot of stuff right there.
It can be.
And I think when you take it in a big bite like that, it can be somewhat overwhelming for somebody who's trying to figure out, okay, this may or may not be before we get to a place where there's brain changes. But if I'm starting to worry about that possibility, or I'm concerned to have a family history, let's start off with how we might get started in smaller bites. So pick one of those and tell me, what would you like us to know as a consumer about one of those topics? Pick one and let's get started.
Well, most of the time when you sit down in the office with me, we're talking about only of immediate death is what people are concerned about. And so what I always bring up, well, what if the unexpected happens? What if dementia does kick in, that diagnosis, or you start seeing changes in memory and memory loss, cognitive abilities? Now we have to look at the future and let's have these documents drafted, even if you're perfectly fine now. What happens 15 years from now, a year from now, and have it in place to where it still protects you.
Okay, so we can start off with what people are familiar with, which is wills. Like, what am I going to do with my stuff when I'm not here anymore?
Correct. And the will is very important, obviously, because it's telling everybody where you want your assets to go when you pass. But another aspect of a will, at least in Virginia, is what if you need Medicaid?
Oh.
And so now your spouse, who is not in the nursing home, isn't suffering from dementia, but caring for you, all the assets, if you're on Medicaid, have been transferred to that individual's name. What if they predecease you? If they predecease you, we want to protect the assets by allowing a spousal special needs trust to be incorporated into the well spouse's will, which protects the assets and allows them to be utilized for the individual who is in the nursing home with dementia and utilized for their care for the remainder of their life, and then those assets pass to who both of you wanted eventually.
All right, so I'm going to pause us here because it's like, wow, even that was a lot. So when we talk about getting started, it sounds like the sooner we start this process, well before there might be shifts, the better. I mean, all things considered. But then we do want to think about the possibility, well, what if there was something besides just dying? And what if even the resources we thought we had weren't enough? Because that's what Medicaid truly is about, is the care that one of us needs in a spousal relationship, or the care that one of us needs in an individual relationship, is greater than the resources I have available.
Correct.
And my life goes on. How am I going to afford this? And we do have to use our own assets, but after that, I still need care.
Well, depending on the state that you're in, and at least in Virginia, you could have $1 million. And if you're a married couple, you could have over $1 million. It doesn't matter. It depends on certain things. But in generality, we could get one of you qualify for Medicaid, even with the assets.
So even with those assets, there are ways to protect the assets.
Correct.
But if I didn't have the assets in the first place, I definitely will need to have something in place, because what if I only have a house and it's a small house?
Correct. There are things, pre-planning is very important. There are trusts that could be incorporated to protect the assets. Most of the time when the couples come into my office, it ends up being where they're in the we need to fix this now mode because they waited too long and we've got to get it in place and start protecting the assets with what we have available to us now. If we do it pre-planning wise, there are other options available. You've all heard about the 5-year look back for Medicaid and that sort of thing, and there's ways to not get around it, but incorporate the plan to recognize it. If you were a single individual and you have the house, there's not as much capability of saving that home. There are options if we have pre-planned for
Okay.
that. Um, there are even options, half a loaf programs. There's all sorts of different strategies that can be used for Medicaid qualification if the goal of the individuals or the family is to protect the assets for their loved ones when they decease.
Or what if I want to make sure that the resources are used for my spouse?
Absolutely. And that
Yeah.
I've had many couples say, I
So
want
you
it
get to
used for me.
pick.
Absolutely.
Okay.
The-
All right. So we're talking about financial assets and the
Correct.
resources. Now let's talk about, though, there's more to it than that, because that's just a piece of the puzzle. The other is advanced directives. And that's where elder law attorneys can be incredibly helpful
Correct.
at getting you to look beyond the immediate and recognize, okay, so yeah, I know I want advanced directives for the person whose brain might be changing, but what about me, the person who's doing the support and care? Because if I am not available, now I've got to think about not only mine and what I want, but how's that my loss, if I'm not here, going to impact the person living with dementia, and what kind of backup plan do we have in place?
Correct. And the
So,
documents are very important. You always want to choose your agents. And when we're talking about the documents, advanced documents or directives, as you stated, you've got the wills, the trust, financial power of attorneys,
yep.
the medical directives, which includes the living will, HIPAA releases. You also got the disposition of remains form, which is very
Oh,
important if you end up having a family that doesn't necessarily get along, and you start arguing. I had it in my own family. You start arguing over the flowers, the music that's played, where the service is going to be
cremation
held.
versus burial.
All that stuff gets discussed. But the most important part are the agents that you choose, and that typically takes the longest time for us to discuss, because you may want to choose your children, but your children may not be the best choice. You may want to choose your spouse, but they are sitting there and you see the cognitive decline. Obviously, you shouldn't put that person there. So then we have to discuss who is the best option for you, and how to, number one, will they accept that role? Will they be able to handle it properly? And if they can't, what are your choices?
Yeah. So now I want to highlight a little bit on that, because does the person have to say yes, or can you put them on there, not have told them, and then when the time comes, it's a surprise?
You can put them on there without asking. Generally, the individuals have already spoken to them, or if they haven't, they are in our office and they decide, okay, I think I want this person because they're good with this. Let me ask them, or I encourage them to go ask them
Okay.
before we draft the documents. And if they speak to the person and they say no, then we change the individual they've selected. I generally like 3 agents listed on every form. A minimum of 3. That way, in case your spouse deceases, in case one of the children decease, you've got a backup plan. And our documents also, and most documents at least should, allow the last agent that's serving to be able to appoint another person for you, so you can avoid the whole guardianship conservatorship issue.
So if we have someone, let's say, that does develop a dementia and it's identified, and I am their healthcare power of attorney, and we'll do the financial separately, but the healthcare power of attorney, and then I get to a place where I'm like, my health is so tenuous right now, I need this to transfer to someone else.
Well,
Is that
if you have the
possible?
competency to
Mm-hmm.
be able to
Yeah.
recognize that, then you are able to simply decline to serve, and it falls down to the next person.
Can I assign another person if I still am at that point and I'm competent to do it? It's just my health is getting to where I'm frail, I've got cancer, something like that, and I know I'm not going to make it to where we're doing it. Can I take that thing that I've done for my spouse and say, okay, I'm going to reassign it, and it isn't who's next on here,
Well,
or not?
you didn't actually do it for your spouse. Your
Uh-huh.
spouse appointed those agents. So
Uh-huh.
your spouse's directions are within that document,
Yeah.
and they have directed who can act for them. And so some documents will have the ability for the very last agent to appoint another agent.
Okay.
But generally, the answer to that question is no, that the primary agent cannot say, you know what, I'm going to appoint so and so because I don't want it to fall to the
So
next.
here's the thing I hope you're picking up on. You do need an expert, and you do need someone who appreciates and understands the complexities. Because the reality is, you do not want to end up, if you can avoid it, in guardianship.
Correct.
You don't want to have to go to court. This is not a comfortable thing for anyone. And I do want us to identify what happens if someone does need guardianship. What is required? And this is for sure in Virginia, but it happens in other states as well. If there is not an arrangement made and nothing has been done, and the time comes that the person clearly is not able to take care of self and or property, what happens?
Well, a guardianship conservatorship action can actually have to take place even if you have the advance directives sitting there. I always tell the clients those directives and those power of attorneys, advance medical directives are only as good as you or the person who signs them allow them to be. And so what I mean by that is if I develop dementia, and I have dementia on both sides, both my grandfathers passed from it. If it comes my direction and I become a problem at home, I refuse to open up the door. I may have the directives in place, but my wife or my agent will not be able to. If I tell them not to go to the bank to do something, they're not supposed to. If I tell them I'm not leaving the house and not going to the doctor, you can't force me to. You don't have the legal right to force me into a nursing home. And so sometimes we still have to file that guardianship conservatorship, even with the directives there, but especially if we don't. If you need access to accounts, if you need to be able to make a medical decision that they're refusing to make for you, then we have to file the guardianship conservatorship process. And in Virginia, it's typically a 2 to 3 month process unless we're able to put it on a fast track, which all depends on the court.
So when we talk about the process of guardianship and conservatorship.
And to clarify that too, because we're talking about multitude of states here. Some states only call it guardianship, which Virginia did for many, many years. Guardian of the person, guardian of the estate. California calls it just conservatorship, from what I understand, which you saw with Britney Spears. And so each state can be different. In Virginia particularly, guardianship is of the person, conservatorship is handling the finances. And with having those do come the complexities for the family that you don't want to have to deal with if you can put the proper documents in place first and hope they work for you. But the guardianship is generally easier to handle. You're making the medical decisions. You become that person's decision maker for everything that they need. The conservatorship is handling just the funds and assets. But then you're also in a situation where if the order is not written correctly, can the assets be used for the surviving spouse that doesn't need the care? Do you have to split the accounts 50-50? The order you have to use an attorney that knows how to draft a proper order, or else the individual who I had a situation where the couple had been married 60 years, assets were joint, but the order wasn't written properly, so 50% goes to one side, 50% goes to the other. And the husband in this case was like, why are we doing that? And then you're having to do accountings with the commissioner of accounts every year for every single dime you're spending. There's different complexities with the conservatorship that if we can avoid it, we try.
Now, here's the side of it from where I sit that makes guardianship so problematic. In most states, and I'm not from Virginia, I'm from North Carolina, we have to go to court to prove you incompetent.
Correct.
And unfortunately, if we're already having challenges, which is why I can't get you to the doctor and I can't get you to sign, I can't get you to allow things and go to the bank. And now we're going to court. And I'm saying, and it has to be whoever is going to do it, I'm saying to my spouse, or I'm saying to my parent, or I'm saying to the person, you're incompetent and I'm going to take over.
Correct.
We are now going to live with that. And people who think people living with dementia are not capable of holding on to information very frequently have the big wake-up call at this point, which is, oh yeah, I remember that you did that.
That is very true.
And so that idea of how do we try to minimize those situations, and that's where skill building before we get there, so that we're not having these relationships coming into the lawyer's office, can be super helpful.
Well, and when you have the individual who, obviously you can have someone who absolutely has no idea what's going on, and in that case, the guardianship conservatorship goes through smoothly. But then you have others where the individual does have some ability, and in those cases, you are having to really dance along the line and make them as comfortable as possible through that process. And that could be adding in additional powers that they get to retain, even if they can't necessarily utilize them.
Right.
Power to vote, power to
Right.
manage certain sums of money, power to still drive. Even if it's written in the order and you know they may not be able to do it, at least they see that
So
it's in
a
there.
sense of control, a
Correct.
locus of control that's sensed, even if in fact that's not going to happen. My sense that I could and I might, that's enough for me. I just don't want to be powerless in this
Correct.
situation. So now you've got me really curious about the extent to which judges, examiners, and lawyers are trained to appreciate and understand aspects of dementia and some of the different unique dementias like Lewy body or FTD or chronic traumatic encephalopathies or posterior cortical atrophy or young onset Alzheimer's.
Okay.
So what in general would you say are the guidelines or rules about the legal practice in the United States right now?
In general, I'll say in general,
In
and I
general,
cannot
yeah.
speak to how judges are particularly trained because I'm not a judge and I don't know. I'm not aware of any specific training for judges or attorneys in specifically dementia or those particular situations you just mentioned. Now, for a guardian ad litem and a guardianship conservatorship petition, they are trained on how to be a guardian ad litem, and it does get into the attributes of dementia in some form or
Alzheimer's
capacity.
or dementia?
That's correct. It's always different. And so, no, the individuals that you're dealing with are not, I don't believe, specifically trained.
Required. There's
I've never
no
taken
requirement.
a specific course. I have learned it through years of dealing with
Different conditions.
different conditions and different clients
Yeah.
within those different conditions. So the knowledge behind it all and what's going to be coming forward is not always there, and it can make it more difficult. But I will say the courts are becoming much more accepting of these situations and understanding when I'm standing there and they see the person who is acting out, upset that they're there,
Yeah.
confused. The judges have been much more receptive to that and understanding, allow them to speak, say what's on their mind, allow them to feel heard, and then make the ultimate decision. And if we can avoid having that person in court, we always try to.
Okay.
I always tell them, do not bring them to court unless they are adamant they want to be there.
Okay. So I'm going to play devil's advocate. I'm
Sure.
sure you're familiar with that.
Absolutely.
Yeah. So I'm a person living with dementia, and I have Lewy body dementia. And it turns out this week, I'm really on top of my game. I'm really quite good, and I'm getting good sleep, and I'm not having delusional thinking. I'm not hallucinating. However, I do think I want to get things done. I want to get things set up because there were some things we didn't do when things weren't right. Now, the one thing I'm having some things with is coming up with the when you say it, the thing that you say, I can't find the you know what I'm saying, when I'm trying to make a sentence and I can't find the
word.
The word, yeah. But I know what I'm saying and I know what I'm doing. I just can't, it's hard to find the exact one that I'm looking for.
Okay.
Yeah. But I wanted to tell you about who should be the person that does, when I'm in the hospital, that makes those choices about the things that happen.
Okay.
Now,
so you just switched on me there. So
I
that was
did,
kind of
didn't
fun.
I?
So you went from the asking me a question to being the person I'm speaking
did.
to. And in this situation, I'm going to continue to ask you questions. And okay, who is the person that you're thinking of? Is it your son? Is it your
No.
No?
Yeah, and so
Okay.
good. And so what you're doing and demonstrating is what a skilled individual would pause and go, okay. So
I would tell you to take your time.
Yeah.
And to relax. When you
Okay.
come in and sit in front of me, I'm not in a suit. Today I'm wearing one, but I generally don't wear a suit in the office.
Okay.
I want the people across from that table to feel comfortable and to build rapport before we ever start talking about business stuff. And I want it to make them comfortable. And if the couple is there and one of them might have dementia or any form of cognitive disabilities, then I don't make it about them. I make it about the well spouse. If this person has the problem, what would you want to
Ah,
save the
okay.
funds, save the assets, have medical decisions made? And that generally will help the person who is having difficulties real because they're always being told, oh, you have this, you have that. We don't make it about them. We
Okay.
make it about the other person
So
and
you
make
can
them
have a
feel comfortable.
conversations that less. So thank you. Now let's pause and let's move over to this idea of what is a pollster, a molster. And I know in each state it's different, but how are you involved in that? What's the legal aspect of that?
I'm going to back you up a little
Go
bit,
for it.
back to where you were a second ago, because your first question was, what if they come in and they've had a week where they're good,
Yeah.
but and they're going back and forth? I just need you to be good long enough to tell me what you need.
All
And if we
right.
can find that time, then I'm okay with that. I will not cross a line,
Right.
but I will help you get things in place if I know you understand it. Can you tell me what your assets possibly are, who your husband or your children are, where you live, what month
Okay.
it is? We go through a general questions that give me the comfortability to be able to do documents. And if I have to, I do them the same day.
Okay.
And so you get them done as soon as possible, catch you in that window of lucidness, and then we can get those documents in place to protect you from whatever it is you're suffering from.
Okay.
Now, back to the pulse that you just
Yes.
asked me about. The pulse, most, post, most, every state has different things. Virginia adopted the post, and I look at that as basically an addendum to what you've hopefully already put in place. But if you haven't put anything in place, that's a discussion between you and the doctor
Yep.
that allows you to decide at the time the doctor is now telling you you have X, Y, or Z, and this is what you can expect from it. What do you want in your future medical decisions? Do you want to have chest compressions? Do you want to be intubated? Those things are what you and the doctor get to discuss, and that doctor is the one who can better tell you what you should put in that document
Right.
versus me sitting in the office when we're preparing for this before any of that occurs generally.
Yeah. So once that document is in place, it has to be renewed every time you go to the hospital, or it travels with you.
Travels with you.
So once you've got it, you have it until you change it, or unless
Correct.
you
Or
change
you
it,
revoke it.
or you revoke it.
And so you yourself can
Yeah.
revoke those documents. If you in Virginia, if you've checked that you don't want chest compressions, the only person that can revoke that is you. Your agent can't on the post.
Okay.
The post.
Okay.
And so it's a very important document to have. And then that
Okay.
also leads into DNRs and DNIs. Virginia does not have a DNI, it has a DNR.
So what's the difference?
Well, DNRs do not intubate,
Right.
do not resuscitate is the DNR. And the resuscitation is very similar to the pulse
Right.
document, no chest compressions. If your heart stops, don't save you.
Yeah.
And I have people who have come in before, they're 50 years old, I have a DNR, and it happens all the time. But what they actually mean is that they've signed an advanced medical directive,
Right.
which is not a DNR. And then I've had others who have been 60 years old and did sign a DNR. And I said, well, let me ask you this. If you have a heart attack in my office right now, do you want us to try to save you or do you not?
Yeah.
Well, I want you to save me. Well, then you need to
Okay.
destroy that DNR
Yeah. Because you're not ready for that.
and revoke it.
What
That's
about
right.
choking?
Choking, just choked?
Well, yeah, either I choked or I have problems breathing and I stop breathing, but it's not my heart. I'm having respiratory distress.
Then you can be saved in that general. I would say that you need to be saved in that situation.
Okay.
Now, I have had a doctor one time who we had an advanced medical directive in place with the client, and we were actually his acting trustee and power of attorney, the firm was. And the doctor, he fell down. He had been diagnosed with cancer as well as dementia. He was not terminal,
Okay.
so he was still capable of living a happy life at that point, but he fell down and broke a hip. And the doctor said it says that he does not want any life prolonging
Extension.
procedures.
Yep.
Well, I said, well, are you hooking him up to machines? No. You're just, I say, all you need to do is fix his hip, correct? And keep him out of the pain. Yes, but he says no procedures. That's not what it means. And we had to educate the doctor in that situation.
Okay. So sometimes the elder law attorney that you pick, or in this case, it was the guardianship.
No,
Conservatorship? How were you? What role were you in there? Because that's
the role the firm had been placed. His
Okay.
family had deceased, and he did not have anyone to help him. He asked us if we would serve as his trustee and power of
Okay.
attorney, and we did that.
So that role. So what you have just heard are personal conversations, but also general ideas that you may want to be thinking about as a care partner or as a person who's considered being a care partner when it comes to matters of legal concern. It's complicated.
It can be.
It can be. And finding a person to work with, a partner for you, the support you need, is absolutely critical. Finding someone you feel comfortable working with and has the expertise that is needed, essential.